Well, good afternoon, everybody. Troy here from the FSC, and it's fantastic to see so many people have registered for our webinar today, Cyber Tips and How to Deal with a Data Breach. A fantastic panel that we have. The usual protocols of online webinars, which many of you will know, an opportunity to ask Q&A. David Ireland, our learned facilitator, senior partner at Denton's, will be facilitating. And David, over to you to introduce the panel and talk about the polls that we'll be running.
Great. Okay, thanks, Troy, and thanks everyone for tuning in. You'll be relieved to know you won't be hearing much from me at all. I'll just be directing the traffic. We've got three fantastic panelists to go through different perspectives on cyber and privacy breaches that we'll be talking through with us today and sharing some of their insights, and look forward to a bit of engagement with them. First up, we're going to hear from Nick Valentine, who is a partner in the digital and data teams at DLA Piper. We're then going to hear from Russell Garrett, who's the executive officer at the Presbyterian Church Property Trustees, and then Philippa Calassi, client relationship manager principal at Mercer, to share her thoughts from the administrative side of the fence. We will have a few polls running through the session. Please feel free to chip in or not chip in on those polls as they come through. I can assure you that there will be no personal data collected, so you don't need to worry about any breaches of the information stats that we do get, although the results will be shared as we go through the poll, just to gauge a bit of a litmus test from people as to what they think about the particular issues we're talking about. And we'll have time at the end to chip through a variety of questions, but please throw up your questions into the chat as we go through, and we'll endeavour to pick them off in the order that makes sense to us. But first up, to set the scene and give us a bit of the, I guess, legal parameters of what we're talking about and what the key issues are around cyber, would like to hand over to Nick. And Nick, the speaking stick is yours.
Thanks very much, David, and kia ora koutou. Great to be here today. Obviously, privacy, cybersecurity, data breaches, it's a huge topic. There's so much to cover. So I think what we'll be doing today is probably just scratching the surface on a whole lot of issues, and then giving you the opportunity to dive deeper through the Q&A into anything that's of particular interest. We're really lucky today, I think, to have Philippa and Russell here, who can talk from an industry perspective and also some personal experience on this issue. As I'm sure David would agree, as lawyers, it's nice to sort of sit here and wax lyrical about the theory, but I think you'll get a lot out of hearing from Philippa and Russell. But with that in mind, I thought it might be helpful just to set the scene briefly in terms of what we're seeing in the cyber landscape, both here in New Zealand and around the world. Just to give some context to the real world experience that Russell and Philippa will be able to share some insights on. And I think it's pretty clear, and I'm sure everyone who's dialed into this webinar would know that the scale and the cadence of cyber attacks and data breaches is continuing to increase year on year. You only need to open the paper or check out the Herald or stuff to find another big, large-scale data breach. We're all starting to get some notification fatigue, I think, because we're just constantly hearing that our data's been compromised. And I think a few years ago, if you'd asked a lot of New Zealand organisations about the cyber risk to New Zealand companies, New Zealand firms, there would have probably been a little bit of naivety, thinking that for whatever reason, the geographical separation, or perhaps we're just doing it better than everyone else, we were a bit more immune than others. And in fact, the FMA in 2019 did ask those questions, and that's sort of what some of the data showed. But that increasing scale and cadence of breaches has really opened everyone's eyes, I think. And for most of our clients, cyber risk is a standing item on the board agenda. In terms of trends we're seeing, I think what's probably most important for this group and for this sector is to understand that attacks on supply chains and third-party vendors are very much on the rise. And I don't want to pick on any particular companies, but I'm going to mention Latitude because they're in the press at the moment for what's now recognised as the largest cyber attack in New Zealand's history. That's been plastered all over the paper, but you actually have to dig through quite a few articles to find out that that was reportedly carried out via a third-party service provider. And it's Australian media that's reporting that that's an outfit, an IT service provider called DXC Technology. That type of attack that comes through the supply chain, through a managed IT service provider, that's very consistent with most of the data breaches that we're helping clients with at the moment, or have done over the last year or so. I think it's particularly relevant in the financial services sector, where outsourcing key IT or key business functions is very common. Regulators are very clear, though, that although you can outsource some of those business functions, you can't outsource responsibility for a breach for sensitive personal information or commercially sensitive data that you're holding. Another trend is that we're seeing a change in attacker profiles. More and more attacks are carried out by increasingly more sophisticated groups with greater resources and technical capability. So cyber attacks are now dominated by organised crime groups and state-sponsored actors. And you only need to look at the massive uptick in cybercrime or cyber attacks launched out of Russia following the Russian invasion of Ukraine. And that's linked to the Russian government or threat actors who themselves have links with the Russian government. And it's important because these organised crime groups and state-sponsored actors have almost unlimited resources. So you're no longer dealing with the teenagers sitting in the garage sort of hacking for fun. It really is the bad guys with unlimited resources. And coupled with that is the fact that it's a lot easier to launch cyber attacks now. There's been an explosion in what's known as ransomware as a service. And that removes a barrier to entry for criminals or threat actors by lowering the technical bar required to carry out a cyber attack. The way ransomware as a service works is that cyber criminals or state-sponsored actors who do have the technical capability to develop malware or to find vulnerabilities or backdoors into systems will then actually license that out to other criminals who want to exploit it, meaning they don't actually have to have code writers or hackers working for them to be able to launch a cyber attack. So really that technical bar that was a barrier to entry to being able to launch cyber attacks has very much been lowered. Just a couple more quick themes. The tactics and methods for extortion, particularly in the ransomware context, are getting more sophisticated. We've really seen a large increase in what's known as double extortion or multi-extortion techniques. So traditionally, you think of ransomware as a bad actor would get access to your systems, lock it down, disrupt your business, and demand a ransom. Double extortion is essentially, in addition to that, the bad guys will exfiltrate your data and threaten to post it on the dark web, and that's also sometimes known as victim shaming. And then multi-extortion can be any number of techniques on top of that. So if you've got a public-facing website, they might threaten a distributed denial of service attack to bring that down. It's all tactics designed to encourage payment in time and in full. And finally, and probably closer to home, it's important to note that the regulators have been a lot more active in policing this issue. The FMA, relevantly for this sector, has issued pretty clear expectations around things like cyber resilience and what to do if you are impacted by a cyber attack. And the Privacy Commissioner, we had a change in Privacy Commissioner almost a year ago, and Michael Webster, who's in the job now, he is taking a much more active and I would probably say aggressive approach to enforcement of data breaches than his predecessor. So David, I'll probably pass back to you. I guess, a bit of a whirlwind, just in terms of some of the key trends that we've been seeing to set the scene.
Okay, great. Thanks, Nick. There, I'm wondering, would it be like timely if we throw up our first poll about how many of our audience think that they may have suffered a cyber attack? Just interested to get some data on that, maybe, and then we can talk to that. So, has your organisation suffered a cyber attack? Noting that a valid response is, I don't know, and often you won't know, right? And you may well be completely compromised, but just interested to see from the audience there. So you mentioned, Nick, about, I guess, that Michael Webster is the current Privacy Commissioner taking a more aggressive approach. Can you perhaps unpack that a little bit? What does that actually mean in practice? Is he a bit shoutier, or is there actual specific things going on?
Yeah, sure. It's a good question. What we're seeing now is, and it's linked to that, the point about the rise in attacks in the supply chain. I think previously, firms who were victims of a cyber attack, particularly one that had originated in their supply chain, were getting away a bit more with the argument that, look, we did everything we could. We outsourced this to a vendor that we'd done our due diligence on. They had some vulnerabilities that we can't possibly have known about, so this isn't our fault. And that was sort of generally accepted as, okay, good enough for me from an investigation perspective. What we're seeing now is the Privacy Commissioner is really pointing at Information Privacy Principle 5, which is a very broad and quite general obligation to protect personal information with reasonable security safeguards. And we're seeing correspondence from the Privacy Commissioner with victims of cyber attacks. When I say victims, I mean firms that have been affected, often through their supply chain, basically requesting a please explain what have you done to comply with Information Privacy Principle 5. And the tone is almost well, you can't have done enough because you have suffered this cyber attack until you convince us that you have done enough, which is a bit of a flip from what we were seeing a couple of years ago.
Right. So effectively, if you've had your, if something's been compromised, you got the breach, effectively, you're then in defense mode of trying to justify why you should not be pinged for it, as opposed to just saying, well, it wasn't my bad, therefore it's all good, and come through. Let's have a look and see what the results of that poll was. Okay, so around half saying that exactly half saying they haven't been affected, and confidently saying no. Nick, does that surprise you, that outcome?
Yeah, it does. I think when I saw the poll questions going in, I would have thought that number of I don't know would probably be a bit higher. And I think I don't know, it should almost be the substitute for no. There's a famous quote from the then director of the FBI, and the quote's probably 6 or 7 years old now, that there's two types of organizations. It's those that have been hacked and those that don't know yet that they've been hacked. I would be surprised if 50% of the organizations represented here hadn't suffered some sort of cyber attack, or at least have some potentially latent malware sitting in their systems waiting to be activated.
Sure. We got a couple of questions that have come through, and I might just get on to those later because keen to drag in our other panelists before we go back. There's a couple of good questions there we can get to shortly. I was wondering whether that poll was a bit of a trick question, that actually the only wrong answer was no, because either you know you have been or you just haven't found out yet, right? So on that happy, perhaps disconcerting note, let's bring in Russell Garrett, who'll be well known to many of you, sort of a long-standing stalwart of the sector with lots of experience with these sorts of things. But you've had an episode that you're happy to talk us through, Russell, but perhaps talk about your organisation and the experience that you've had with cyber attacks.
Thanks, David. Yes, kia ora koutou, ko Russell Garrett, toko ingoa. I'm the Executive Officer for the Presbyterian Church Property Trustees, and we're an organisation that was created under the Presbyterian Church Property Act of 1885. So when David says I'm a long-standing player, I haven't been around quite since 1885. And I'm sort of happy to talk about it. It would be better if I hadn't had this experience, but it's a really good forum to be able to share, a little bit about our experience. In terms of our organisation, we hold property for the church north of the Waitaki River, and we also supervise a number of trusts, part of which is that we have a corporate trustee custodian company that looks after the minister's superannuation scheme. So that's most relevant to this forum. And it's also relevant to know that we're a very small outfit, so we outsource most of our services, including our IT services. So we've got an external IT provider. And just as Nick said, that's the scenario through which we experienced the breach. So what I'm going to talk to you about over the next 3.5 hours or so, sorry, 3.5 minutes, I could talk for 3.5 hours, for the next little while is one breach, two obligations, and the Otara Millionaires Club. So first of all, I'm going to talk about the breach. On the 30th of November last year, we were advised by our IT provider that some hackers had gained access to their data centres and deployed some ransom software, or ransomware for those in the know, which had encrypted all the data on their servers. So they're an IT provider that looked after a number of organisations, small and large, including some government departments and Crown entities. And so all the data on those servers, on behalf of all those organisations, had been encrypted. And for the payment of $1 million, that data could be recovered. We were then advised that the data, the bad actors, as Nick talked about actors, we talk about bad actors in this sense, and we're not talking about thespians, had removed data belonging to 5 of those organisations. Nick used the term exfiltration. The data had been exfiltrated. One of the things about cyber attacks is you've got to get used to a new set of lingo. And subsequently, we were advised that the data on behalf of those that had been taken from those organisations was in fact loaded onto the dark web and available for those people who know where to look. So that's a really brief synopsis. My first takeout about this experience is it's actually quite difficult to comprehend what's gone on. And that's for 2 reasons. The first is this is stuff that's happened in the digital world. It's tech stuff, and people who talk about it and know about it use tech speak. So if you are someone like me that doesn't live in that world, you've got to get used to a whole lot of new language pretty quickly. The second thing is it's actually quite difficult to know with confidence what has actually happened. The hackers might tell you what they've done, your IT provider or your IT team might tell you what they think has happened, but it's actually quite difficult to know. And maybe the best way I could describe it is it's a bit like a burglar's entered your house, got into your office and changed the locks on all your filing cabinets. So you can see and know that they've changed the locks on your filing cabinets, but you don't know whether they've taken anything out because you can't get into the filing cabinets. And you don't know whether they've gone into any of the other rooms in your house and left anything secret there or taken anything from any of those rooms. So there's an element of, we think we know what happened, but actually it's quite hard to really know with confidence. So that's my brief synopsis of my breach. The next thing I was going to talk about were 2 obligations. And the first is an obligation under the Privacy Act. And that's pretty important for the context of this forum. So the first question we had to ask ourselves or answer is, what data was affected? The good news for us is that we outsource our superannuation scheme administration to Melville Jessop Weaver. They weren't at all affected by this event. So, most of the member data wasn't subject to the cyber event. However, our office gets involved in new member activity, so onboarding ministers and helping them to join the fund. And in that process, we hold some identity verification data on our systems. So straight away, we were able to identify that we had some personal data that was affected by the cyber breach. We also hold data on behalf of our directors, similar sort of data. And even though the data hadn't been taken, we had lost control of that data. And that meant that under the Act, as far as I'm aware, that's a breach. However, we then had to determine whether or not that breach was likely to result in serious harm to the individuals. And because we were confident that our data had been locked up but not taken, we felt that that it was extremely unlikely that any harm was going to come from this breach. So we made a judgment call that we didn't have a notifiable breach under the Act, and we used the advice of quite a good solicitor called Nick. And Nick, I wonder whether you just want to confirm, and just clarify the sort of the legal position, because this is pretty important when it comes to your obligations under the Act. It might involve some judgment. Thanks, Nick.
Yeah, that's exactly right. I think just touching on that first point, what you experienced was your data being locked down. A lot of people wouldn't sort of consider that to be a data breach because there's no evidence that anyone's accessed it. It's just that you can't access it. The Privacy Act, the mandatory data breach reporting regime, was introduced to the Privacy Act as part of a suite of changes in 2020. And unlike some other legislation around the world with data breach reporting language, our Privacy Act expressly classifies a privacy breach, or includes in the definition of a privacy breach, temporary or permanent loss of access to information. So you're exactly right that there was personal information that had been locked down. There was temporary loss of access to it. So you're in privacy breach territory. What you then need to assess, because the obligation under the Privacy Act is that you have to notify the Privacy Commissioner and affected individuals as soon as practicable after becoming aware of a notifiable privacy breach, so not any privacy breach. And a notifiable privacy breach is essentially a data breach that's reasonable to believe has caused or is likely to cause serious harm. And as I'm sure you'd agree, Russell, when you're going through, there's a lot of stuff going on apart from just this privacy breach notification assessment, but looking with a bit of granularity at that particular part of the breach response, if you do suffer a breach, the assessment of serious harm is probably the thing that you'll be debating the most, because it is a bit subjective. The Privacy Act does helpfully list some factors that are relevant in assessing whether or not there's been serious harm. So actions taken to reduce the risk of harm following the breach are relevant. So, for example, if you can quickly get the data back, if this wasn't the case for you, Russell, but if the data had been exfiltrated, and I'm now conscious of the jargon I'm using, thanks for pulling me up on that, so I'll do my best. If it had been, but you managed to pull it back or stop it being leaked, that might take it from notifiable to not notifiable territory. The inherent sensitivity of the information that's been affected is relevant, the nature of the harm that could be caused. And this is an interesting one because there are lots of different types of harm that can be caused. We often default to financial harm, identity theft, fraud, etc. But we have helped clients who've inadvertently disclosed personal information or the current address of a wife that had split up from the husband and had an anti-violence order against him and had hidden her address from him, and all of a sudden he was in possession of that information. Now that's clearly a real risk of serious harm. So I just mentioned that to sort of turn your mind to not just thinking about potential financial harm. Another factor, who's obtained or could obtain access to the personal information, particularly relevant in the data breach scenario or the cyber attack scenario, and going back to the changing in attacker profiles that we're seeing with these incredibly sophisticated organizations now committing most of the cybercrime or the ransomware attacks. You're almost always a high risk on that box or that factor of the assessment. And finally, the final factor in the Privacy Act is whether the personal information is protected by a security measure. But again, looking at the sophistication of the people that are carrying out these attacks, what we're finding is sort of basic encryption is probably not enough to really stop them getting access to the data. So there's a lot that goes into that serious harm assessment. If you come out following that assessment with a view that there is a likelihood of serious harm, then you have to notify the Commissioner and affected individuals as soon as practicable. If it's not practical to notify individuals individually, you have to issue a public notice. There's no time frame specified in the Act for notification, but following the Waikato DHB cyber attack, the Privacy Commissioner issued guidance that he expects notification within 72 hours of discovering the breach.
Thanks, Nick. So, that's it is actually quite a complex decision. You need to know, my takeout here was, you need to know what data you've got where, and the decision around a breach is subjective, and taking advice is really important. So that was my first obligation. The second obligation I wanted to talk about was you may have an obligation to your insurer if you've got a cyber cover in place. And so this is a good time for our second poll. Rebecca, I think you could please pop up the poll. Does your organisation have a cyber insurance policy in place? And just to keep it simple, we've got the same 3 answers we had last time. Yes, no, I don't know. As it happened, we did have some cyber cover in place. And if you do, you've got an obligation to your insurer to make sure that you are taking reasonable steps to mitigate the potential cost arising from, from the cyber attack.
Was there any of your engagement with your insurer that might be helpful to share with the audience today, Garrett? Russell?
Yeah, a couple of things. First of all, it's if you do have a cover in place, it's worthwhile going back and making sure that you answered all the questions on the application form accurately, because without casting any aspersions on insurers, any opportunity to review your case is what they're likely to do. So, and this is a technical area, and maybe when you filled out the application form for cyber cover, you kind of just were somewhat general. So make sure that the information you provided your insurer is accurate. If details have changed in terms of your IT arrangements, make sure you alert your insurer. The second thing is you get given, there we go, 70% of people have got cover, 63% of you have got cover and 22% don't know. So most people have got cover in place. Which I think is a good thing. So our experience was you get given a claim, a breach coach. Now, if you think this sounds a bit like a digital midwife, which is what I did when I thought about a breach coach, you're kind of right. They're there to help work through the claims process and the event for you, but they actually work for the insurer. So, what they're trying to do is they're trying to help the insurer work through the claim. But they can be really helpful as a part of as you work through this whole thing, because they will have experienced things. So they provided good advice. For instance, one of the things we had to do was they recommended that we get an independent forensic cyber team to come and review our other systems to make sure that these bad actors hadn't left any other malware anywhere. So, before you suddenly leap back into doing things, you want to make sure that the systems you're using are quite appropriate. So, working with your insurer and making sure that you fulfill your obligations to your insurer is the second obligation. The last thing I wanted to talk about was Paulie Fuimani and the Otara Millionaires Club, or OMC for people who might know it better. And of course, that means operate, monitor, and communicate. So whilst this is all going on, you've actually got to continue to operate your business. And that can be difficult if your files are locked away and you don't have access to your files. We still had our Microsoft 365 system, so we're still able to use emails. We've got a board management software, but a software that wasn't affected. So we could continue operating, but we did get a cyber audit of our systems completed before we jumped back in to do anything. We also communicated with our external providers, particularly around the superannuation scheme. So we went to the administration manager and said, if you get any instructions that look a bit weird from us, please check in with us before taking action. And so we instituted some callback protocols around instructions, because once again, we weren't sure to what extent these hackers had infiltrated, the systems. It didn't seem that wasn't an issue, but you don't want to make assumptions about that. So working on, just getting operating can be quite a challenge in the midst of a breach. The second thing is you want to be monitoring what's going on. You need to be you need to understand that the situation's developing. Is anyone thinking about paying the ransom? What are the other victims? How are they responding? Have they been told the same things as you? There's a lot of noise in this process, and it can be difficult to understand what's going on. So you need to invest in monitoring and keeping up to date with what's happening. And the last thing, just briefly, is communication. Understandably, there's a lot of communication you have to enter into. So I just put a little list together. In addition to your IT provider, we were communicating with our legal advisor, our insurance broker, our breach coach. We did communicate with the Privacy Commissioner to alert them to the fact we've been affected. Our breach wasn't notifiable, but we elected to let them know, in part because they knew stuff was going on anyway, because a whole lot of other people were talking to them. CERT NZ, which looks after some IT sort of compliance safety issues. We communicated with the FMA. They communicated with us on multiple occasions as a part of their monitoring role. We've got a board of directors. I've got trustees. We've got scheme members. We've got other scheme providers. We've got our forensic cyber team we're working with. I'm letting my auditors know what's going on. I'm communicating with other victims, and I'm trying to keep my staff in the loop. So suddenly this thing can take over your world for a few weeks as you try to stay in touch with stuff. You try and keep operating. You're trying to meet your obligations, and you're trying to keep people in touch with what's happening. So that's my one breach, two obligations, and the Otara Millionaires Club. David, thank you.
Excellent. And you've now extended that fairly exhaustive communication to include us. So thank you for not stopping there. And you just don't stop. Really keen to bring in Philippa, who's been sitting there very, very quietly, patiently for the past half hour, listening to all of that. A lot of your thunder has already been stolen by Nick and Russell of what they're going through. So I think you've still got a couple of bits to talk us through. And one question that came through, I suspect a bit tongue-in-cheek, that should we all be heading back to paper-based systems to protect privacy? I suspect the genie is out of that bottle, and we ain't going back. There's also, of course, a whole extra layer of privacy or breach issues with paper-based systems and what can happen there, which Philippa may talk to us a bit about shortly. But really interested, Philippa, from that perspective of a scheme administrator and the systems that you have in place and the approach that you take re data protection, and recognising that not all breaches that we're talking about here are actually malicious, that actually it's not just the bad actors that we need to look at, it's perhaps the inadvertent actors or stuff that happens. So over to you just to talk through your experience in this space.
Okay, thank you, David. We've heard a lot from Russell on the privacy breach thing, which is great and good to have that practical example. Privacy breaches follow the key principles of contain, assess, notify, and prevent. And as you work through the process, it all kind of blurs in together in a very short time frame. Now, one of our restricted schemes experienced a privacy breach soon after a trustee's procedure was developed, and it was a really good test of process to work through. And this was actually an example of a paper-based breach. In this example, the member's annual confirmation statement was sent out to an address, only the member no longer lived there, and someone who lived at that address opened it up, saw that it was all this personal information, and contacted Mercer to let us know. And so it was great because that person, upon realising the error, destroyed it and told us that had destroyed it. So on receiving the notification, the administrator advised the scheme's privacy officer and also lodged an incident in Scout, which is our incident management tool. And that has the impact of advising the risk and compliance team, as well as Mercer's privacy officer. So as a privacy officer, the first step from a trustee scheme perspective was to actually reach into the trustee's privacy breach procedure document. And it was really good because it was a clear step-by-step process which worked through what you do, and it included all the regulatory obligations and definitions. And from that, we were able to quickly ascertain that the address used and where it was mailed to was the address we held on file. The member hadn't advised of us of a change of address, and the breach was very much limited to one individual. And in fact, as we worked through the process, it's a technical privacy breach. It's at the lower end of the scale. Immediate risk mitigation had occurred. As far as we knew, the statement had been destroyed. And as far as we knew, the breach had been contained. We then worked through the assessment and notification side of the incident and called the member and let him know what had happened. And it was a little tricky to find the phone number of the member, but we got there in the end. And it was really good. The member was able to confirm that he was comfortable with the information having been destroyed, and that from his perspective, he didn't think any further action was needed. In fact, actually mentioned that he should have really updated his address when he shifted. We then emailed the member, and we did this to just outline the conversation we had had and write that written summary of events. Also to confirm in writing the new address that had been given over the phone, because we didn't want another breach to occur in any kind of manner. And we also advised that the annual confirmation and annual report would be reissued to that address. We directed the member to the website, which, there's a lot of online tools out there. And I think, going back to paper-based would not be an ideal world from a provider perspective. And, there's a lot of online tools where you can update your information. So pointed him in that direction. But as part of the process, we needed to let the trustee know. And the chair of the trustee was advised immediately by phone call, and then there was follow-up emails. And the Mercer's privacy officer was also contacted again to see what their thoughts were on the breach and whether it was notifiable and their assessment of materiality. So once the chair and I had confirmed that we didn't believe it was notifiable privacy breach and that Mercer was of the same view, we went out to all the directors of the board and got their view, because that's what the procedure said that we needed to do. And they all came back and they agreed that it didn't meet the threshold for serious harm. The sponsor's privacy officer was also informed, because that was part of the procedure. So it's not just the provider or the scheme, it might be the employer, whoever. And so we needed to make sure they were in the route. And he was also of the view it wasn't notifiable. And as an aside at the end, we went back to the person who opened the envelope in the first place and just let that person know that it had all been resolved, to close that loop as well. So while the immediate incident had been managed, it was important to consider how to prevent a future occurrence, and also whether any of our processes needed to be altered. And as mentioned, the breach also highlighted that the member hadn't used the website, and in fact had never used the website. So some of the things we considered were there enough preventative flags and mail stop measures in place? Was the current member messaging sufficient, encouraging people to update their addresses? Did we need extra communication? And would there be opportunities that would raise member engagement of the website that would also help prevent these things? And just in general, were there any other things that needed to be considered? Throughout the whole process, we're very cognizant of the privacy breach guidelines and the importance of following those. And we did have a number of observations, which I'll share with you now. And as Nick said earlier, members are trusting, the trustee and scheme providers to keep their personal sensitive information safe. And that's what we all need to do. Providers need to ensure that they have effective systems, processes, and people in place. But that also means you need the people to be trained to recognise a breach and know what to do if one occurs. Trustees need to ensure that they have a documented breach procedure and privacy statement. It needs to be pragmatic, provide definitions and the clear procedures to follow. Trustees also need to have confidence in their providers' systems. Providers will have their own privacy incident procedures. So as Russell alluded to, you've got multiple processes working at the same time. You've got the scheme, you've got the provider, you've got the employer, the sponsor, and it's all happening at the same time in a very short space of time. And what we definitely found was preparation was key. It's important to understand your privacy breach procedure and the regulatory requirements prior to a breach occurring. When a breach occurs is not the time to learn the process because the timeframes are incredibly tight. And it was good to hear Nick saying in terms of, that reasonable time frame of notifying the Privacy Commissioner. Well, it all happens really quickly, and ours was a very low-level breach in terms of, the extent and breadth, but it still consumed, a good couple of days just working through the process, contacting everyone and making sure everything was in writing. So, it's also important in following the breach guidelines. You've got self-assessment tools. So you've got the privacy breach guidelines that the Privacy Commissioner puts out. You've got the self-assessment tools. So, use them, use the information. It's great information to refer to. And if you use the tool, keep the answer from the tool as evidence as to how you reached your conclusion, because it is subjective. And so it can be challenging at times to, what does this mean? So use the tool and use everything that you've got. Communication is absolutely key. And you've got to keep all the parties informed. And I would say too, it wasn't necessary in our case, but seek legal advice earlier rather than later if you really don't know what to do. Because if they haven't been here before, they'll find a way to navigate through, and you do need that support. The other thing I found was the breach was a really good opportunity to see how the process and procedure worked. And so it's a good opportunity to review it and in need, amend it. But yeah, so that was more what I had to say. I probably haven't answered your questions, David.
No, that is all good. I might bounce back to Nick just to get a reaction on a couple of bits and also answer a couple of the questions that have come through. The feeds and that nicely, but I think what you've just been talking about now, it sounds like so Mercer did, like everyone got onto it pretty quickly, even though it was a relatively low-level breach and knew what to do. So keen to perhaps throw up our third poll question, which was how confident people are about their organisation's staff's knowledge of their of what to do in the event of a data breach, and the response to that. Hopefully, that survey will come up shortly, or that poll. If Rebecca's still there, we can throw that up. If not, perhaps there we go. Here's our poll of how confident are you about that staff actually know what to do. So it seems that promptness of understanding throughout the organisation is quite key, even recognising something as a breach. But Nick, interested perhaps just in your reaction to what Philip has just gone through, but perhaps also I think it dovetails a bit into a couple of these questions about how organisations do know if they've outsourced some of their scheme admin to Mercer or other functions, what level of assurance should they be looking for to make sure they're going to tick the box under Privacy Principle 5 around taking adequate security measures, that sort of thing. And probably you got about maybe a minute, 2 minutes to deal with that. I realise it's a very big question. That might be for the section 2 of this particular theme. Over to you, Nick.
Yeah, thanks very much. Look, I'll probably try and answer both of those questions in one go or in one response. Philippa obviously gave a very good overview of the benefits of having a plan in place and a process so that you're not learning things on the fly. And that's absolutely critical. I think another thing that that everyone who's listening today should be thinking about doing is a data mapping exercise and a vendor mapping exercise to understand where your data assets are and the criticality of the vendors in your supply chain. And that exercise will feed into, or at least help you partly answer the question about what should we be doing or what more can we be doing with our vendors to build cyber resilience into the supply chain. And there's a good resource from the NCSC, the National Cybersecurity Centre, around how you do build cyber resilience into your supply chain. I'd encourage you to have a read of that. But at a very high level, what you should be thinking about doing varies depending on what tier your vendor fits into. So is it absolutely mission critical? Does it have unfettered access to your systems, your customer data? Well, you should be doing more with that person than, say, someone who just supports a back office application where there's no real sensitive information hosted, or if that system or that platform goes down, it's not going to really impair your ability to do business. I think in terms of what you can actually be doing, due diligence on your vendors' security resilience. I know that the FMA really likes the American NIST cybersecurity framework. So there's a lot of due diligence questionnaires you can find out there if you don't have your own one to assess an organization's maturity against the NIST framework. That would be a good place to start. Requirements to comply with your security policies and make sure you're updating and evolving those over time as the threat landscape changes. And don't just file that due diligence response that you did before engaging a provider away in your top drawer. Get 6 monthly or annual attestation, or if you've got any concerns, ask for that questionnaire to be completed again. You might not have a contractual right to do so. Ideally, you would. I know a few good lawyers that could negotiate a contract with you with a clause like that in it. But if you don't, just ask for it from a relationship perspective. Most vendors are used to seeing that these days. I wouldn't get too hung up on things like your own rights to conduct penetration tests and get in and look under the hood, because frankly, not that many organizations actually have the internal resources to be able to avail themselves of those rights. And secondly, most mature vendors, in whether they be IT vendors or managed service providers, whatever it may be, are very reluctant because to allow their customers access to their systems, because that in itself creates a security risk for them. If you have a vendor that rolls over and lets you access their systems, I'd probably be questioning what is their cyber resilience actually like.
Bit of a giveaway, right? How do we get on with the poll results, Rebecca? Throw those up. Right. Okay. Probably really good that there's a very tiny percentage don't know in some ways. Let's get that confidence about people knowing. It does seem to be key. And Russell, how do you think your organisation would have stacked up on this particular poll? Without putting you on the spot.
Yeah, well, I think we were more on the, it was a learning exercise for us. We did have some protocols in place around, the due diligence and ongoing due diligence on our providers in terms of seeking attestations from them, asking them about their, penetration testing results. But we hadn't gone through the data mapping exercise that Nick talks about. Although we're quite fortunate, we're relatively small, so we can respond pretty quickly to this sort of setup. But it was and has proven to be a reminder to our boards around the criticality of this. We are going to engage, some additional independent and get, seek some independent advice around cyber governance. There are now, advisors out there, so you just have to add that to your, the list of people you get helping you if you're a scheme provider. You've got your legal advisors and your compliance advisors and your investment advisors and your administration advisors. You've now got to throw in, someone that's assist you with cyber governance and cyber security. I think that's just going to be the way of it.
Yeah, I think you're right. Nick, any observations on that before we jump theme?
Just to say that those numbers in that poll result don't surprise me. I think this is a sweeping generalization, but if you look at probably the target audience or the types of people that register for a webinar like this, you're typically reasonably au fait with the governance processes of your own organization. So you yourself will probably have a pretty good idea of your own maturity. The challenge I would give you is these attacks, particularly from the more sophisticated threat actors, can come from anywhere, and often the initial indication you'll get will be at the endpoint, a laptop or a phone, of if someone in the organization that might not actually sit on exec meetings or sit in management committees doesn't necessarily know that the board has approved a data breach response plan. So I think a key theme today has been communication. I mean, that communication in advance of a breach is also key, just making sure all of your staff are aware of where to escalate to, how to find the documented processes for what they should be doing.
Cool. Yeah, no, a good tip. Hey, look, I'm conscious we've probably only got about 5 minutes left of chat. There's been a couple of good questions through that we might catch up and even address in the session 2 of this, which we're planning to do later in the year. One of the things that we did chat about, I think Russell and Nick have touched on it when we were preparing for this, was ransomware and I guess payment of ransoms and that whole gnarly issue of, do you pay the ransom? What's the bits there? Just interested in, maybe it's a Nick or Russell comment to just start us off on a brief chat on that.
I'll make a brief comment. In our context, it was relatively complex because multiple organisations were involved. So our IT provider, worked with 30 or 40 outfits, including, as I said, some government agencies and Crown agencies. You factor in multiple providers. People are talking to their insurers. Various insurers will have attitudes towards ransom payments. There was some concern about whether or not, for example, because it was a suspected Russian actor, whether we'd be breaching any US bans on dealing with certain outfits out of Russia. So it became quite tricky. In addition to the moral questions around whether you want to pay or not, and of course it doesn't deal with the data breach. That's already happened. All it can do then is work out whether you get your data back more quickly or whether maybe you can minimise some harm. But to some extent, I think it's something that happens afterwards. You've got to deal with a lot of the breach stuff first.
Okay, well, you mentioned that moral question about, so let's throw up our final poll question before we get to Nick to get your take on it. And the final poll question is, would you refuse to pay a ransom on moral grounds? Which perhaps there's 2 elements to that. Would you pay the ransom? And if not, would it be on moral grounds or not? But perhaps, Nick, could you just chip in with your take on payment of ransoms and ransomware?
Yeah, I will. I won't front run my thoughts on that response, on that question before we've actually got the responses.
Right.
Look, I think just in terms of giving you some data, law enforcement and most of the guidance from the regulators and the industry bodies that you would see would advise against paying the ransom. The data varies from report to report, and obviously organisations that do pay a ransom have a good reason to want to keep that quiet. But some of the more reliable data we've seen suggests that somewhere between a third and half of businesses do pay a ransom demand. Recent data would suggest that is declining a bit year on year. But again, you do need to take that data with a bit of a grain of salt, because this is sort of by design quite a secretive part of decisions businesses are making. As Russell mentioned, you do need to be aware of any legal restrictions on making payment. New Zealand doesn't have any legislation expressly prohibiting against ransom payments. And I think it was a year or two ago, the government said they weren't planning on enacting any. But there are things like AML CFT laws and restrictions on making payments to countries or groups or individuals subject to UN Security Council sanctions. So some due diligence on who you'd be making payment to is required, and determining whether that person has or that group has any apparent connection to terrorism. What I'd say is, and this is absolutely critical, is that this area of law or the sort of governance and regulations around payment of ransoms is not static. Countries around the world are looking at how or whether they can and should, and some already have, legislated against it or put some controls around payment of ransom, which might be you can pay a ransom, but you have to report it to the government or a particular regulator. So just make sure that you're completely across what your potential obligations are there. And finally, just remember that if you have decided that you probably do need to pay the ransom, you can negotiate, either to buy yourself time or try and negotiate the ransom down. That's probably not something I'd recommend just having a crack at yourself. There are specialist ransomware negotiators who can be quite effective. Again, this is a place where data varies, but a report I looked at from a cybersecurity firm for covering 2022 indicated that the average discount for ransom payments was 81% on asking, and the median discount was 42% on asking. So it's likely that the first number you get thrown is a big one, but don't necessarily think that that's the final number.
This is their business, right? And you make a judgment call. Firstly, if I pay the ransom, how will I know I'm going to get my data back? And what we were told was, this is their business. This is ransomware as a service. Software as a service. This is ransomware as a service. And we were told that generally, because they want to, do this to other people and get paid, if you pay them money, they will release the data. But I'll clarify, in our scenario, there wasn't a ransom paid by us or anyone else, but just demonstrates how complex it is.
Thanks for clarifying that. I know there's one particular public sector organisation where that was not made public as part of the Official Information Act request or sort of going through, but we won't have time to get into that. Interesting comment just came through on the chat about paying a ransom in cryptocurrency is not easy for first timers, which would probably be a fair comment, but even though it might be the requested form of payment. Conscious we are getting, for 27. Hey, Philippa, perhaps one, last comment for you or input from you from the extent of the policies that you got in place, and from your example, any additional learnings or thoughts around, adequacies of policy? Is there a danger with all the complexity we talked about of actually trustees getting drowned in too much policy paperwork to actually have a process to follow? It seems there's a lot of steps, and already you're struggling to follow all those steps you need to take. And what's your spin on it as experienced administrator?
Yeah, I think it is. It certainly wasn't. It was a time condensed working through process, but it was a good process. And I've certainly been impressed by trustee boards and the procedures they've developed. Most of them have been developed in conjunction with their legal advisors. But also from a cyber perspective, Mercer, MMC, we have our global systems and cybersecurity. So from that perspective, I would hope that the numbers on that poll for confident that they would be confident that we would have protection in place. But the trustees, of course, if the breach occurred in a trustee's laptop or a cyber different environment, then that opens up a whole nother question as to who's covered then and how.
Right, we might need to close you off there then. Just conscious that Troy's coming up online to boot us off because we've reached the end of our allotted span. And just behoves me to thank the three of you for sharing your experiences and wisdom. Nick, thanks for that detailed run through. There have been a couple more questions we haven't got to, as it's said, particularly one about engagement with the FMA in relation to these sorts of breaches, I think is a really interesting one. We've probably got enough content there to help inform the next session, which we are hoping to do later in the year. So thanks everyone for your participation and the comments and questions through. Troy, hand over to you to wrap us up.
Thank you, David, and thanks to the panel. And just to note that the recording of today's session will be up on our website by the end of the week. And we will hope to see as many of the people who've registered today and these faces today at our conference in August with a bit of luck. So until then, thank you all so much.